3 sub 1 sub D, they're allowed to seize if they believe that an offense has taken place, and they can only release when they're fully satisfied that there's no violation. There's actually some symmetry with the provision in this Act. If you basically give the government a power to seize when there's a violation, and they can only release when there's full compliance, that's what you're going to get. And inspector after inspector told us under oath, well, the only consideration was whether or not they were in compliance. If you pass this Act and you give the inspectors the power to take control over private property, to check for compliance, to ensure compliance, that's what you're going to get. You will get exactly what you give them. And, you know, if I'm a property owner and I have an inspector acting reasonably and they're treating me well and they seize my stock and I don't get to go to court and they charge me for an administrative violation and the state forfeits my property, it doesn't matter how reasonable that was or wasn't. It's a move away from the rule of law. It's a move away from procedural fairness. So I'm willing to presume that Health Canada right now is committing to acting reasonably, but that's not the issue. The issue is do we give a reasonable person these powers? And I think also it's fair to assume, I mean, laws are passed and they stay there for a long time. And you're giving people enormous discretion on some very significant property right issues.
Small
Sure.
supplementary.
Go ahead.
Health Canada has been very forthcoming with respect to a long consultative process on the regulations, which of course will shape what the statutory reality is on the ground. In your judgment, is there any regulatory specificity that might emerge from those discussions with various parts of the to-be-regulated industry that could provide a measure of either confidence or balance relative to how the statutory parts of the law were in fact enforced? What constitutes a risk? What constitutes a problem? Definitions of what constitutes, for example, the issue my colleague Senator Eaton raised, what constitutes a private or a non-private facility that may be subject to search and seizure, those sorts of things. Do you have any hope, or do you have any belief that an honest regulatory process where there was open consultation could provide some measure of comfort for the vast majority of manufacturers, producers, wholesalers, importers who are honorable people and who want to go about their business in an honorable way? Or do you fear that if the legislation passes, then the regulatory process will in somehow not be managed honestly, or really has no hope of generating the kind of balance and fairness which clearly on the trade side in one case and on the purveyor's right side you're looking for in your submissions to us today?
I think, first of all, when a law is passed, it's now going to be the courts that interpret the law. So let's assume we're not dealing with the constitutional challenge. We're just, the court is interpreting the law. The court is not going to be swayed by, you know, some modus operandi between industry and Health Canada that, you know, may have commenced to grease passage and gain support for a bill. The court's going to interpret the law according to, you know, a whole set of procedures for statutory interpretation. And also I would say that Health Canada is obligated once the law is passed to enforce it in its true meaning and not to shackle itself by policy. So it's just an interesting question, because I think the responsibility of both the House and Commons and the Senate is to ensure that it's passing laws, first of all, that are clear on things like risk. I would echo my friend's comments on how vague it is, the concept of risk. And yes, if there are questions, well, what is private property? Is the law of trespass abolished? These things actually should be very clear going in. They shouldn't be subject to opinion. I mean, laws are supposed to be clear. They should be defining, with some certitude what's going on. And I wasn't focusing on the ambiguity in this act, and my friend covered that, and there are a lot of ambiguities. And I have to say I would have difficulty instructing clients as to the scope of the act. But clearly, whatever the scope is, it shouldn't be bound by a policy or, some agreement between industry and Health Canada. And I don't think that that's really a consideration that the Senate or House of Commons should be taking into account. Just that's my opinion.
And in addition to
yes.
what my friend said, I'm going to go back to your very first question that you asked, Senator Siegel, is what's happening? And from the international perspective, I asked the question as well, what is happening? Is this a reaction to some of the international scandals that came out of China and elsewhere a year ago? And so if what we are doing is we are reacting to some external issue, and it's going to be in regulations, are we going to be putting ourselves in a situation where those regulations will change as the wind changes, as we react due to media attention to some of these issues? And while I trust regulations to be put forward in good faith, I also trust that we react sometimes, and the changes can be made so that a particular circumstance can fit into a regulatory regime, and so that action can be taken to erect a blockage at the border. And that's where my concern is in looking at, if we could have stopped the milk coming in to Canada, luckily there wasn't any coming in, but, would we then create a mechanism so that we can do that very quickly? That's not necessarily a bad thing, but what if we've got a different good where we don't have the scientific evidence, but there is this public reaction, this public outcry, and what then, and do we have the right balance? That's really what my question is.
Thank you, Chair. If I could have a chance on the second round, if there is one.
Okay, put you down for that, if we do get there. Senator Ogilvie from Nova Scotia.
Thank you. Mr. Buckley, during the time that I came in and listened to your testimony, if I understood you correctly, a great deal of what you were saying had to do with what I think a term you actually used, the state seizure of property. And if I heard you correctly, the state was in the person largely of regulators who would be carrying out the action of the state. And I heard you explicitly start a major portion of your commentary at Article 31 of the Act, leading you through to the seizure and disposal of property in Article 61. Mm-hmm. Now, my reading of the bill has that by Article 31, a number of steps have already been initiated to provide the individual, corporation, or other identified object of product contravening or potentially contravening the Act, a whole series of steps in which they have the opportunity to comply and to conform to the Act, or to show that their products do in fact conform within proper legislation. And indeed, Article 31 says that if that person has not complied up to this point, a series of steps can be initiated with regard to stopping manufacture, et cetera, and can provide an order in this regard. But this notice, the order, must include a statement for the reasons of the measure and the time and manner in which the measure is carried out. And then once again, the individual, corporation, or whatever is provided with time to comply, and on it goes through a series of events. Now, I guess I'm having difficulty understanding why society can't lay out a reasonable set of steps that allow an individual, a corporation, or other entity to comply and show that a product is safe within the terms of safety within the Act. And if they continue to refuse to do so, surely at some point there reaches a stage where, if there is sufficient grounds,